Good morning, everyone. My name is Nina Murray, and I'm Head of Policy and Research at the European Network on Statelessness, and it's a pleasure to welcome you all on behalf of ENS to this webinar today, our State of Play Assessment of Statelessness in Europe for 2024. For those of you not familiar with ENS, we're a civil society alliance of over 180 individuals and organisations across 40 countries in Europe. We're working to address statelessness together through law and policy development, awareness raising and capacity building. We're really excited to have had nearly 200 registrations for the webinar today, and I can see already that we're close to 80 participants with us at the moment. So in just a few seconds, we'll be posting a short poll to find out a bit more about our audience today. So today our webinar is launching updates to 15 of our country profiles in our Statelessness Index, along with 2 new country profiles for Turkey and Georgia, bringing the total coverage of the index to 32 countries across Europe now. And the index is one of the key resources that we have at ENS to address statelessness in Europe, but others are available as well, depending on your area of work. So do please check out our website and related tools and resources. We are recording today's session and we'll make it available publicly afterwards. So do please feel free to share with colleagues. There will be an opportunity to put questions to our panelists throughout the webinar today, so do please use the question and answer function to ask questions as we go along. My colleague Alexia is monitoring the chat and will be answering questions there, and we'll try to answer a few of your questions at the end if there's time. If you have any technical issues, we also have our communications colleagues online today, so do drop a line in the chat if you need any support there. We also hope that you'll stay engaged beyond today's session, so feel free to email us afterwards if we don't have time to answer any questions you might have or with any comments or feedback. So the aim of today's session, today's webinar, is to present the key trends and data emerging from the Statelessness Index, to reflect on progress over the last 12 months to address statelessness in Europe, and to identify key areas for action going forward at both national and regional levels as well. So after we hear from my colleague Patrícia, our legal policy coordinator, who's going to present our state of play analysis, we have a fantastic panel of speakers for you today. We're really excited to have 3 of our national country experts with us to explain more about some of the gaps and opportunities in their context relating to statelessness. And we're delighted to also have with us Jana Toom MEP, who's going to address the regional context and statelessness at EU level in her intervention later. So without further ado, let's get started. And I'm going to hand over to Patrícia Cabral, who's our legal policy coordinator, and she's going to present our state of play assessment, as I said before. I think you're seeing the poll results in front of you at the moment, so great to see that we have a mix of people who've used the index before and who don't know about it. So welcome to those who don't know about it, and hopefully you'll know more by the end of the session. And some interesting comments on what people think has improved or not improved in relation to statelessness in Europe. So perfect timing and bridge to Patrícia to tell us our thoughts on the state of play in Europe currently. Over to you, Patrícia.
Thank you, Nina, and good morning, everyone. It really is exciting to see lots of new people who aren't so familiar with the index, so I'll try and do a little introduction to it as in the beginning as well, but also to particularly thank those that are in the room that are researchers and that contribute to the index. It is a big effort that doesn't come just from the ENS Secretariat, but also from the ENS members that we have partnerships with for the index and that have put a lot of sweat over the year into making this happen. So thank you to those of you. And I will, hopefully by the end of the webinar, you'll have a better idea of what has improved, what hasn't changed so much, and also some of the steps backwards. So it's actually a mix, but the answers tend to be pretty accurate. So that's a good sign. I will just start sharing my screen so I can introduce you a little bit to the index. Essentially, just give me a second. So essentially, the Statelessness Index is a comparative tool that is available for free online, and it compares the performance of countries in Europe against international norms and good practices. So essentially, it examines how countries are doing to protect stateless people in their territory, and also what they're doing to prevent and reduce statelessness. So it was launched in 2018. We're now entering the 8th year of the Statelessness Index, and it's a very easy way to understand what are the differences between countries, but also to assess them. So there's a scoring that we give on different areas of the index that assesses how close countries are to performing the best practice and the best international standards on each of the various issues. It currently has 32 countries, because 2 of the countries that we're adding today are Georgia and Turkey, and you'll hear from the experts on Georgia and Turkey soon as well. And it has been now updated with 15 new country profiles. Over 2023, it already had over 17,500 users just last year. So it really continues to be an essential tool to raise awareness and to inform advocacy across Europe, which gives us a lot of hope for future change, and essentially is an incredible knowledge tool that can really push for change as well. So I was just mentioning we are launching 2 new profiles and 15 updated countries. For these 15 updated countries, essentially what they are doing is reviewing the laws, policies, and practices, what has changed in their country. And this is done with a contribution from index country experts. You'll hear from 3 of them today, from Salome, Robin, and Melis. And they send us all of this information, and then we process it in the ENS Secretariat to produce the country profiles that you see available on the website. So we're really grateful to the work of our country experts, and this just wouldn't be possible without them as well. The way that we do this, we have a particular methodology. So we have developed a list of norms and good practices, but across 5 different areas. And then for each country, we benchmark against those practices. And we also compare to how the country is doing across across Europe and in comparison to other countries. It's a live tool. Whenever there are significant changes, we publish news updates or we publish a new analysis on it. So it tends to have quite up-to-date information, and it's a good way for you to stay informed about what's changing. It's used both by civil society, practitioners working in the area, but also by governments to identify what are the key areas that they still need to improve, and also to find the best practice examples across Europe and perhaps follow the good examples from other countries as well. So moving on to what has changed over the last year and what is the current state of play assessment of statelessness in Europe. We were doing a similar webinar a year ago, and that's when we kind of reflected on essentially 4 key areas that needed urgent action. These were introducing statelessness determination procedures, strengthening safeguards to prevent childhood statelessness, addressing discrimination as a root cause of statelessness, and then also improving data collection systems to identify statelessness across Europe. Detention is also a key area that needs improvement, and all of these areas still need urgent action, but we have actually seen a lot of positive developments across all of these areas, although we have also seen some missed opportunities over the last year and a couple of steps backwards. So let's see what has changed, and also what was the result of some of the political negotiations that were going on a year ago, and some of these have now been resolved and have made its way into law. The index has 5 areas, which are the ones that you see listed here. Some of these haven't seen a lot of change, so I won't focus on them. For example, international and regional instruments, the only change that we've really seen is that the Netherlands has withdrawn its reservations to the 1954 convention. And for example, on detention, there haven't been significant changes, or on statistics as well. So I'll focus on actually statelessness determination and status, and also on prevention and reduction. On the protection afforded to stateless people, there have been new mechanisms to determine statelessness that were introduced. And in total, there are 14 out of 32 index countries that have statelessness determination procedures in place to determine who is stateless and grant them protection. This increase in the number is partly due to the fact that we added Turkey and Georgia, which both have an SDP, but also because Albania has now adopted the instructions that were needed to operationalize the SDP that it had approved in 2021. So that's actually a good increase in numbers. However, Europe is not really leading this at a global level, and is still falling behind other regions. For example, the Americas have really good protection systems and have been increasingly implementing and improving them. So there is a lot of catch up to do. And this is also despite the fact that almost all countries are party to the 1954 Convention on the Status of Stateless Persons that essentially grants stateless people a number of rights, economic and social rights, and grants them protection. So the countries are party to this convention and must grant these rights to stateless people. But in order for them to access these rights, people need to be identified and need to be granted a residence permit. And this is what is failing in some of these new mechanisms to determine statelessness as well. So, for example, in countries that have procedures to determine statelessness, but where it doesn't lead to a protection on the basis of that statelessness, then we wouldn't consider them to have SDPs. This is, for example, the case in Belgium, which has a procedure to determine statelessness, but recognition doesn't lead to a residence permit. And the Parliament is now currently still discussing a proposal to establish a new procedure that grants stateless people a residence permit, but it also has a few concerning features that we've noted in a joint opinion with our member Nansen. The Netherlands has also approved some of the long-discussed legal reforms on statelessness, and that includes a procedure to determine statelessness that has both an administrative and a judicial route, but it's also criticized for not leading to a residence permit or protection. But you'll hear more from Obrin about this soon. Then in July last year, Czech law has also implemented a procedure to determine statelessness, but is also insufficient because it only leads to a tolerated stay for the first year with very limited protection. And so again, this is just not sufficient to grant the rights that stateless people are entitled to. One other positive step is that Portugal has approved the legislation that defines who is a stateless person and recognizes that they are entitled to a statelessness status in a travel document, but it hasn't yet approved the procedure itself needed to access this and also the rights that come attached with statelessness status. So we are waiting for that development to continue. Essentially, Europe needs to continue introducing statelessness determination procedures, and there are several examples of good practice to draw from in the index. So I do invite you to have a look at that if you want to see some of the good examples too. In terms of prevention and reduction of statelessness, and particularly here on prevention of childhood statelessness, almost half of the European countries still permit children to be born stateless on their territory. And Switzerland, Romania, and Cyprus have no safeguard at all. This is actually exactly the same sentence that I said a year ago. The only change really has been that Moldova has improved its safeguard to prevent childhood statelessness, which used to be dependent on the parent status, and now it applies to all children. So that's a really positive development. And the Netherlands has also extended the right to acquire Dutch nationality to stateless children without a residence permit who were born in the Netherlands, but that's still subject to proof of uninterrupted stable residence for 5 years, so it's also not applicable to all children. The index shows that even where states have safeguards in place, sometimes these are inadequate, or authorities don't implement them in practice because of several barriers or because they're unaware of the safeguard. And sometimes it has also been, the concept of statelessness has also been misinterpreted to the point that it excludes children from accessing these safeguards when they should be entitled to it. And we have seen an example of that in Belgium, for example, where municipalities have been incentivized by the Immigration Office to not grant Belgian nationality to children born to Palestinian parents because they consider that they wouldn't otherwise be stateless. And we have also published some information and analysis on this to condemn this practice. I'm wrapping up in a minute, Nina, thank you. finally, just on there's been a bit of mixed developments in reducing statelessness. So on naturalization, actually, this is one of the areas that we keep on pushing for because it's the only way to resolve statelessness. It's to really grant people the right to nationality. And there aren't a lot of facilitated routes to naturalization across Europe. And what we have seen this year is a restriction of these routes. So we've seen stricter eligibility criteria for naturalization across Cyprus, France, Ukraine. So this actually prevents stateless people from even accessing a way of naturalizing and ending their statelessness. But to end on a positive note, it's really positive that North Macedonia has developed several legislation packages last year, and it's addressing existing cases of statelessness while also taking preventative action to stop it from reoccurring. And so this includes, for example, documenting individuals that had been identified as not having their status regularized, securing routes to confirmation or acquisition of nationality, but also simplified procedures for birth registration. And likewise, Ukraine has been putting some intentions on strategizing new ways of promoting civil registration and documentation. And just the final note to say that after this analysis, so over this year, we're also going to be updating some of the thematic briefings that we have already published, one on birth registration and the one on stateless and discrimination procedures, so that you can see updated information and comparative analysis over these two themes across the index as well. And we'll be publishing 2 new countries, but you'll wait until next year to hear about that. Thank you.
Thank you so much, Patrícia, and apologies to rush you, but we have to move on to our exciting panelists and give them a chance to hear from each of them. But that was a really comprehensive overview of the updates, some positive, some less positive over the last year. And again, we'd welcome any questions or thoughts in the Q&A from listeners. So without any further ado, I'm going to turn to our first panelist to hear their reflections and responses and comments on their national context. So our first panelist is Salome Jakhadze from Rights Georgia. Salome is our country expert on Georgia, and we're really excited to have her with us to tell us about this new country profile that we've added to the index this year. So Salome, over to you.
Thank you, Nina. Good day, everybody. I'm just gonna start sharing my screen. So thank you so much to the ENS team, the whole team, and also to the UNHCR colleagues for all the hard work put into into creating the Statelessness Index for Georgia. And I'm really excited to present the country profile for Georgia today. This really important tool for us as well to analyze what have been done and what is still in need of addressing from the state. So I'm going to jump right into the details of the index, and of course I'm going to start with the international instruments and very briefly just brief you that Georgia has acceded to the two most relevant and important conventions related to statelessness, which is 1954 convention related to the status of stateless persons, and the Convention on Reduction of Statelessness. Which is important to note is that the conventions do not have direct effect in Georgia. The provisions are reflected in national legislation, and through them, through the legislation, they are enforced and have the effect in the country. So just a bit also about the situation in terms of statelessness in Georgia. As of summer to 2023, there had been a bit more than 500 recognized stateless persons in the country, but of course there is still remaining risk that stateless persons may be underreported. So to address this issue, the Public Service Development Agency, together with UNHCR, undertook this huge throughout the country mandatory door-to-door campaign, which was one of the commitments made by Georgia in 2019. And it really had significant effect in the sense that many of the undocumented persons were granted Georgian nationality or another country's nationality was determined for them. And there are a couple of cases still pending at the administrative level for the SDP. When it comes to SDP, a status determination procedure itself, Georgia has, as Patrícia also already mentioned, Georgia has already established dedicated SDP, which happened in 2012. And since then, the process had been, of course, evolving. And at the moment, it is significant to note, on a welcoming note and positive note, that there is no application fee for status seekers as a barrier to restrict them to apply for the statelessness status, as well as there are neither the time limits to apply for the status of stateless person, as well as there is no lawful residency requirement in the country, which is really a positive thing. And from the moment of applying for the statelessness status, the residence permit is automatically granted to status seekers, as well as they are provided with temporary identification cards, which is valid for 1 year. Here, I have to note that the legislation establishes the time frame for SDP, which is up to 9 months, but even if in cases when it may be prolonged for different objective reasons, the temporary ID card can be renewed, and this does really happen without any problems in practice. So the temporary ID card is provided throughout the whole SDP, which is a really welcoming regulation. From the moment of applying for the status, the status seekers are equipped with basic rights, which are basically the same as for Georgian nationals is provided. Right to work, education, as you see here as well. It's really important that they are included in the emergency healthcare system. But there are, of course, some exceptions as well. Just, for example, right to vote or to be elected to the public office is not provided for status seekers. In addition to what is provided to the status seekers, already recognized stateless persons are automatically provided with residence permit, with a 3-year residence permit that can be renewed. And what is really noteworthy here, and have to underline, that Georgia has really significant success in facilitating naturalization, in the sense that, first of all, there is no application fee to apply for Georgian nationality. And as of the end of last year, the resident or lawful residency requirement in Georgia, which is in general 10 years, has been halved, and it's 5 years for recognized stateless persons right now. So this is a really welcoming step. But of course, we also have to address the gaps which still needs to be further discussed and addressed by the state, and I have to start with the state-funded free legal aid for stateless persons, which is not at the moment provided for either at the administrative or the court level. The legal consultation is the only thing that is covered by the state legal aid service. Another thing, and this is really an important point, is that from the moment if the administrative body delivers the negative decision and rejects the claim application about the statelessness status, a person loses lawful residency in Georgia, and the temporary ID card is also no longer valid. And this is true even if the person appeals against the negative decision to the court. So while the litigation is still pending, they are no longer residing lawfully in the country, and this is especially alarming in the sense that there is no safeguard against the detention or the expulsion in such cases. This is I have to note that this does not happen in practice. So we have not had any cases where a person was detained or expelled, but this is not something that is safeguarded by the law. Also, unlike asylum system and refugees in Georgia, the right to family reunification is not provided for stateless persons as well. Regarding the acquisition of nationality and childhood statelessness especially, there are some safeguards. In Georgian legislation, for instance, foundlings are presumed to be Georgian nationals unless later on otherwise is determined, or and as well children born on the territory to recognize stateless parents, or whenever one parent is stateless and the other is unknown, Georgian nationality is also granted in these cases. But the major gap here remains still in place, and this is that the law does not provide for children born on the territory who otherwise would be stateless. They are not granted automatically Georgian nationality, and this is a huge gap that still needs to be further addressed, and the advocacy point onwards as well. Only the last point I wanted to make, and I hope I'm within my time allocated. This refers to persons fleeing war, and in Georgian context, as I believe in many different places and countries, primarily we're thinking about Ukrainian refugees and people fleeing war from Ukraine. In Georgia, the legislation does provide one of the forms of international protection, which is humanitarian status, and this is exactly granted in the situations where in the country of origin there is the ongoing war, armed conflict, etc. So this does cover people fleeing Ukraine and fleeing war. And what is important is that this status is not bound by the nationality. So stateless persons fleeing war are also covered under the or can be covered under the humanitarian status as an international protection mechanism, and there are really flexible documentation requirements by the administrative body, so there are no specific documents that had to be submitted to the relevant administrative body, which is also a positive thing in terms of protection of stateless persons. So this is very briefly on the profile, and thank you once again for the opportunity.
Thank you so much, Salome. That was really succinct and clear overview of some of the positives and some of the challenges. So thank you very much. There may be some questions and we may come back to at the end, but I'm going to move on now to our next speaker, our next national expert, who is, I'm delighted to introduce Melis Gebeş from Refugee Rights Turkey, who is in the capacity building and advocacy unit at Refugee Rights Turkey and our country partner in Turkey. And Melis is going to introduce some of the positives and challenges remaining in the Turkish context as we launch this new country profile. So over to you, Melis. Thank you very much.
Thank you, Nina. Let me share my screen first. Yeah. Hello, everyone. I'm pleased to be here today. As Nina said, representing Refugee Rights Turkey, an NGO headquartered in Istanbul. Our main mission is to improve the legal protection of refugees and other vulnerable migrants in Turkey. And we have also been working together with ENS to tackle the issue of statelessness in country. Before we explore Turkey's statelessness challenges, I would like to thank ENS colleagues for their invaluable collaboration and commendable efforts in compiling the country profile of Turkey for the Statelessness Index. And today I will present the key points of this important topic. To begin, I will provide a brief overview of the country's context. As known, Turkey holds a strategic position at the crossroads of global migration routes. This makes it both a transit and a destination country for people on the move. Currently, it hosts the largest number of refugees worldwide. There are 3.1 million Syrian refugees and around 320,000 refugees from other countries, mainly from Afghanistan, Iraq, and Iran. Turkey's asylum system functions under a dual structure, meaning that there are two main protection regimes. Syrians are covered under temporary protection regime, which provides the group-based protection to those fleeing the ongoing war in Syria. This includes Syrian nationals as well as refugees and stateless persons from Syria. And asylum seekers from other countries are eligible for international protection. In Turkey, there is no alarming incident to stateless populations who face the denial of their nationality rights within the country. Rather, statelessness arises in migratory context. In terms of Turkey's international obligations, among the two core statelessness conventions, Turkey has only acceded to the 1954 convention relating to the status of stateless persons, and unfortunately it has not yet a party to the 1961 convention on the reduction of statelessness. Regarding the other UN conventions that include provisions on statelessness, Turkey is party to all of them, but with reservations. However, none of these reservations are related to statelessness. As to the regional conventions addressing statelessness, Turkey is not a member state of the European Union, but it's a member state of the Council of Europe. However, it's not party to the two conventions on statelessness within the Council of Europe. It is only party to the European Convention on Human Rights. In terms of stateless population data in Turkey, I must say that the topic of statelessness remains largely unexplored. To the date, there has not been a mapping study conducted on the country's stateless population, but there are publicly available official data on the stateless population in Turkey. However, these data are unfortunately incomplete and insufficient. This, of course, makes it challenging to get a full picture of the magnitude of stateless population in the country. In Turkey, as Patrícia mentioned, there exists a statelessness determination procedure, the SDP. I will go into its details shortly, but no data has been published on the number of applications, approvals, or rejections under this SDP. This also presents a significant barrier to understanding how the SDP is actually functioning and its impact on stateless populations, stateless persons in the country. In Turkey, there is a legal framework establishing a dedicated SDP. This SDP is located within the administrative structure and conducted by the migration management authorities. The SDP leads to the issuance of a stateless person identification document, granting stateless status to those determined as such. This ID is automatically renewed every 2 years as long as the person's statelessness situation continues. The ID grants the right to stay in the country and serves as a substitute for a residence permit. Stateless status holders cannot be deported unless they pose a serious threat to public order or public security. They have the right to apply for a travel document and a work permit. They also have access to education and basic healthcare services. However, the most important thing in terms of Turkey is that there is a lack of awareness about the SDP among the stakeholders, and the available information is not detailed enough, and that is not disseminated properly, which in practical terms hinder its access for the potential applicants. And in terms of prevention of statelessness, in Turkey, stateless individuals do not have a facilitated route to naturalization. They can apply for Turkish nationality under the general conditions established in law. And these conditions include meeting requirements for residence, language proficiency, good character, income, and having no criminal convictions on pending trials. On the other hand, in Turkey, there are relatively good safeguards in place to prevent childhood statelessness. Under the relevant provision, Turkish nationality can be granted to otherwise stateless children born in the country. However, this is not an absolute provision, but a conditional one, meaning that Turkish nationality is not granted automatically, and there must be an application along with the submission of certain documents, such as a birth certificate and a birth registration. And in practice, unfortunately, it is not always possible for refugees to obtain this documentation due to various reasons, such as lack of awareness among the parents about their requirement to register the birth of their child, and also home births, which are prevalent in some refugee groups that prevent the issuance of a birth certificate for the child born in Turkey. As a result of this issue, some refugee children, especially those born to Syrian refugees in Turkey, face the risk of statelessness. Among the challenges around the statelessness in Turkey, this is actually the most pressing concern currently. In addition to the problems with Turkey's legal framework and its implementation, issues such as serious gender discriminatory nationality laws play a role too. Because these laws deny mothers to confer their nationality to children born outside Syria, when the child's bloodline from a Syrian father cannot be established. And currently, it is estimated that in Turkey, a substantial population faces the risk of statelessness. And in closing, I can say that the issue of statelessness in Turkey is a complex and multifaceted issue, and there are ongoing challenges concerning awareness of the issue and the relevant legal structures for protecting stateless individuals and also preventing statelessness, particularly those focused on preventing childhood statelessness. And we need to continue working together to raise awareness in order to create a better environment for those affected by statelessness in Turkey. Finally, you can find my organization's Refugee Rights Turkey's contact information on this slide. And on behalf of Refugee Rights Turkey, I thank Sigrid Razing Trust for supporting our wider work on statelessness in Turkey. And also I thank again to ENS for their support to our work under the Statelessness Index, including completing the Turkey's country profile. And I thank the audience for their attention.
Thank you so much, Melis, for that really comprehensive overview. That was great, and there may be some questions later, but thanks again, and it's great to see Turkey added to the index now, and thanks for all your hard work on that. So I'm going to move on now, though, and we'll come back to you if there are any questions. So next, I'm really delighted to introduce our country expert for the Netherlands, Robin van Oene, who's going to give us a bit more detail on the update of the Netherlands this year, as there have been some important changes over the course of the last 12 months. So thank you very much, Robin. Robin is statelessness coordinator, I should say, at our member organization in the Netherlands, ASKV. Robin, over to you.
Thank you so much, Nina. Let me then share my screen. Okay, thank you so much, ENS, for extending the invitation to talk a bit about the situation in the Netherlands. Indeed, there have been quite significant changes recently in the Netherlands, and I'm happy to talk to you all a bit about what those changes mean in practice for stateless people in the Netherlands. I work for ASKV. It's an Amsterdam-based NGO primarily focusing on undocumented migrants, rejected refugees, and stateless persons all over the Netherlands. And ENS and ASKV have had a long relationship working together, also on the legislative developments that have been recently implemented in the Netherlands. So statelessness in the Netherlands. So today I want to talk a little bit about the new statelessness laws. It's part of a legislation package that includes like a new law, the Stateless en vaststellingsproceduurewet, or the statelessness determination law. But it also includes some changes to existing laws, as well as an executive order establishing an administrative route for determining statelessness. Statelessness had a long history in the Netherlands. Like the Netherlands ratified the 54 Convention already in 1962. It ratified the 61 Convention in 1985. So it took a couple of decades in the Netherlands to actually implement a procedure to determine statelessness and then be able to provide protection to them. But first, I would like to discuss a little bit like the numbers and like what to put statelessness a little bit in context in the Netherlands. So the last numbers, a little less than 30,000 people are currently registered as stateless or with an unknown nationality in the Netherlands. These are people that are currently lawful stay, and there are no reliable data on the number of people without lawful stay in the Netherlands that might be affected by statelessness. This graph or this map shows the country of origin of the people that are currently registered as stateless in the Netherlands. Maybe good to note that before the legislative changes, there was already some sort of an administrative procedure in place that, as you can see, is primarily targeted towards Palestinians, because the Netherlands do not recognize Palestine as a state, and therefore Palestinian citizens are considered stateless in the Netherlands. The data is of 2020, and the reason for that is that that's the last year that disaggregated data was available. The map shows, the labels are in Dutch, but I think it's quite clear that it shows that the vast majority of people that are currently registered as stateless are coming from regions where Palestinian refugees normally reside. This is the same map, but then with the different data. This is the people that have an unknown nationality currently registered in the Netherlands, so they have a residence permit. And this shows a much more diverse country of origin dispersion. Interestingly, the biggest number is actually born in the Netherlands. So a lot of children are born in the Netherlands with an unknown nationality. There's still quite a large number of people coming from the MENA region, as well as from former states, including the Soviet Union and former Yugoslavia. The legislative process, just wanted to give you guys a quick overview of like what happened in the last 12 years. So basically the whole dialogue about statelessness in the Netherlands started in 2011 with a UNHCR report that concluded that the Netherlands lacks an effective statelessness determination procedure. And our government was quick to respond to that, like, nah, there isn't really an issue here. Shortly thereafter, other reports, among others by the Advisory Committee on Migration, a government body, they signaled like maybe there is a problem with statelessness in the Netherlands, maybe we should do something about it. It took still like a couple of years to come to a first draft of the new legislation. There was a draft that ASKV, the Institute on Statelessness and Inclusion, and ENS were quick to comment on. And finally, in 2020, the new legislation was proposed to Parliament. Almost simultaneously, the Danny Zhao case happened, which was a case that came before the UN Human Rights Committee of a child born in the Netherlands with an unknown nationality, in which the Human Rights Committee concluded that Dutch legislation and practice was not in line with international standards. The package was approved by the House in 2022 and approved by the Senate in 2023, which set an implementation date for the 1st of October 2023. So the outcome. So what do we have now in the Netherlands? So we have a procedure to establish statelessness. So we can determine statelessness both administratively or via a judicial process. A designated court can apply the definition of a stateless person directly, and different types of evidence are admissible to the court. There is legal aid available, but applicants cannot appeal the decision to the High Court. The administrative procedure focuses on obvious or more evident cases of statelessness that are like easy, between quotation marks, so that clerks can basically establish it like faster than going through the court. Importantly, the procedure cannot be defined as an SDP because there's no protection status attached to the determination of statelessness, so it only leads to the right to obtain an identity document, which clearly state the holder of the document does not have legal stay or lawful stay in the Netherlands. Also, during the procedure, there's no protective status, which also leads to some accessibility concerns, because the lack of this legal status subjects people to detention or even removal from the country, that also negatively impacts on the will to basically access the procedure, because people are like, is it really worth the risk to go through this system? However, we still see it as a step in the right direction, because before this we did not have anything, and this is admittedly not great, but it is a step, and we're also working very hard together with ENS and other partners to challenge the new laws either in court or through advocacy. It's good to note like that also the new procedure, it was established in quite a complex political environment, accumulating in the last election result where the far right overwhelmingly won the election. In the whole process of this legislative development, we were quite busy to propose for changes, but the main political party was quite clear that if these changes were accepted by Parliament, they would retract their support, and then the whole laws or the whole package would have failed. The lack of a protection status is maybe showed by the case of Yuri, who is a citizen of the former Soviet Union, who arrived in the Netherlands in 2001. So that's quite a number of years ago. The labels are, again, apologies in Dutch, but basically every label signifies a legal moment in his procedure. And this basically shows that even though someone's statelessness is established, in his case in 2014, it still takes a lot of years in order to get a protection status. He got it in 2021 after establishing his statelessness in 2014. Then the changes on the prevention of statelessness. So this is like adjustments to the current to an existing law, the Rijkswet op het Nederlanderschap, or the Dutch nationality law. The changes establish a second route to Dutch nationality for stateless children born in the territory. The granting of nationality for these children is not automatic, however, as the parents of the child need to file a request at a municipality. And what Patrícia also mentioned, the requirements are quite stringent, so it does not apply to all stateless children born in the Netherlands. The first route was already enshrined in the law before the recent changes, and that basically applies to stateless children born in the Netherlands with a residence permit. They have to have been stateless since birth and 3 years continuous lawful stay in order to obtain Dutch nationality directly. Quite recently, we challenged the old law in court, and we got a judgment from a multiple judge chamber back in December, stating that the lawful stay requirement was in fact violating international law, and we'll be using that judgment also in challenging the new law. You can find it in the statelessness case law database as well. The new route for stateless children born in the Netherlands without lawful stay basically establishes a second procedure for children that do not have a residence permit, but the requirements are quite more stringent than the first procedure. It requires an uninterrupted stable residence for 5 years. The children have to have been stateless since birth and show that they are unable to reasonably obtain another nationality. And lastly, which is, I guess, the most problematic, is that the child and their parents have to have always been visible to authorities and have actively cooperated with their own removal attempts. In the initial procedure, the initial proposal, the time period was 10 years, but this was later changed due to an amendment in court or in Parliament. And this is one of the laws that we're currently also working on with new procedures and establishing like case law on this topic, basically, because in the current requirements, it's so strict that, like, for example, with ASKV, we don't know any families that may be eligible for this procedure. I'm gonna leave it at this, and if there's any questions, I'm happy to answer them later. And thank you again very much for this opportunity.
Thank you so much, Robin. That was really interesting and a really clear kind of overview of some of those changes, some positive, some steps in the right direction, as you say, but also some remaining challenges to be addressed. So thank you very much. And I'm going to move straight on to our final speaker. So I'm delighted to welcome Jana Toom MEP, who is here to give us a regional perspective on the issue. I'm really delighted Jana's agreed to join us at what is a very busy time. We recognise nice, so thank you. And Jana is one of a growing number of MEPs who's been supporting ENS's work and doing great work to mainstream statelessness across different EU policy agendas. So we're really keen to hear your thoughts, Jana, on what the EU has done to address statelessness recently over the last 12 months or so, and what more could we be doing. So over to you. Thank you very much.
Yes, thank you. Thank you very much. Thank you for having me, and thanks to all the panelists. It was really very interesting and educating, and some things I would say were also optimistic, but of course not all of them. I have to admit that this is kind of personal issue in our office for my assistant Vlada. She's former stateless person from Latvia. My father, who passed away a few years ago, also was stateless in Estonia. So, I mean, we know pretty well what I was speaking about. And this is, of course, one of our priorities here. We know that we have 500,000 stateless persons in the European Union, and 2/3 of them live in the Baltic states. And when we say Baltic states, we, of course, speak about Estonia and Latvia. But I don't want to speak about my countries, maybe a bit. If we speak about European context, of course, the most powerful tool we have is already mentioned Convention 1954, related to the status of stateless persons, and 1961 Convention of the Reduction of Statelessness, and also European Convention on Nationality. It was already in 2012 when the EU had made a pledge that all member states will exceed the 1954 Convention, but Poland and Estonia still have not do so. But it's not enough just to agree with it and to ratify it. You also have to follow it. And here I have to mention that we have some very worrying developments right now in Latvia. I'm here in European Parliament. One of my positions is Vice Chair of Committee of Petitions. And on Monday, we had this Monday, 2 days ago, we had 4 petitions from Latvia, where almost 1,000 people are under the risk of expulsion from the country due to the fact that they did not pass Latvian language exam, and they are Russian citizens. But not just Russian citizens. They are former non-citizens and former Latvian citizens, which means that these people who were stateless in Latvia and due mainly to economic reasons got Russian citizenship because Russian pension aid is almost 10 years lower than Latvian. And during previous economic crisis, there was huge unemployment. So many of them took Russian citizenship, and now they are to be deported from the country, which is very bad development and very worrying. But fortunately, European Commission is also worried, so we hope that we can stop it. But nevertheless, we see that some conventions can be ratified on the paper, but never taken into account seriously. If we go to EU legislation, generally the trend now is to treat stateless people in the European Union as a vulnerable group. And this is included in a lot of different European documents, like EU Migration Pact, Anti-Trafficking Directive. Yesterday we submitted, I'm shadow rapporteur on Directive on Consular Protection, and we also submitted amendments there, which are not adopted yet, but we hope that they will pass, where we try to put also stateless people in European Union under consular protection of the state which gave them travel document, which means that it has to be some European member state. However, it always falls short of real rights. While stateless persons are mentioned, real obligation on member states never make it through the negotiations, which is disappointing. And we know we have a bad joke here in the Parliament that all our political ambitions are always killed in the Council of European Union. As you know very well, there are 3 co-legislators in European Union, Commission, Parliament, and Council. And Council is the place where all of our ambitions are, severely cut down. Now, if we speak about identification and prevention, identification mechanism to prevent statelessness is needed. While it is enshrined in the treaties that every member state decides who is a national, nothing prevents the European Union from developing a directive on identification of statelessness. And given the migration influx, that will be very reasonable to set up EU-wide standard for identifying stateless persons. And I believe that this has to be our nearest goal and ambition for the next parliamentary term and the term for European Commission also. If we speak about access to nationality, the need for inclusive nationality laws, that allows stateless individuals to acquire nationality through simplified procedures is needed. Several member states already did so, as we know. But EU can also take steps to extend rights to stateless persons and to approximate those rights to EU citizens. We had an attempt to do so through European long-term residence directive, and Parliament supported amendments. But now, unfortunately, this directive is blocked in the Council, so we will come back to it in the next mandate, but nobody knows what will be the composition of the next Parliament. So we'll see. A more drastic step would be to fully extend EU citizenship rights to long-term residents. But of course, such a not controversial in my view, proposal can only be done in the right political climate, which we obviously lack today. If it comes to preventing arbitrary detention and expulsion, of course, stateless people are most vulnerable group in this context, and we have to advocate for measures to ensure that stateless individuals are not detained solely on the basis of their statelessness, and that their right to seek asylum or other forms of protection is respected. Furthermore, safeguards that prevent expulsion of stateless persons need to be properly implemented. And we're seeing here dangerous trends in my home country, Estonia. We had deportation of stateless person. Her name is Zoya Palamar. It happened exactly on the day when we were in Madrid in this conference of statelessness. It was on 9th of June. They did not deport her. They just waited until she left the country, and then she immediately got an SMS that she is not welcome back. Now she's in Russia waiting for a court decision. There was no court decision whatsoever. So it's very dangerous trend, and we have to stop it until it spreads all over Europe. And of course, the last point is awareness and advocacy. Awareness raising and advocacy in addressing statelessness are extremely important. We have to encourage civil society organizations, media, educational institutions to raise awareness about this problem and to advocate for the rights at the national and EU levels. There was, as we know, United Nations campaign that was launched in 2014 to end statelessness in 2024, and we can see that this campaign unfortunately failed, but this failure needs to be reminded to politicians so that the issue continues to be a priority. I believe I fit in 8 minutes, huh? Thank you.
Thank you so much, Jana. Thank you for being concise, but also a very rich contribution, highlighting some really important points. And I hear your message that, it's not enough just to ratify international and regional instruments. We need to see that gap between accession and implementation addressed. And, it's good to see some of those examples of mainstreaming of statelessness and awareness across EU policy agendas, but there are still challenges, as you highlighted, remaining. And we would certainly agree with an important focus going forward being on EU-wide harmonization of identification of statelessness as a key priority. But yeah, thank you so much. Really rich and valuable, and lots to reflect on. And we're coming up, unfortunately, to the end of the webinar. So if everybody could quickly switch back on their cameras, we can just say a big thank you to all of you for your contributions today, from our national experts in Georgia, Turkey and the Netherlands, from Jana and your regional perspective and the important points that all of you raised. It's clear, I think, that we need a more concerted regional strategy to address statelessness. We hope that the index is a useful tool in both national and regional level advocacy. We're going to be posting a very quick survey shortly to all of our listeners. I see we have nearly 100 people still with us at the end of the hour, which is a great sign that it's been a very engaging webinar. So please do look out for that survey, everyone who joined us today, and it would be great if you could give us your feedback on the webinar. We encourage you all to access and share the index online. Use it in your work. Please do send us comments, questions. We've answered a couple of questions as we go along, but if you have other questions, do feel free to reach out to us, and we can also pass those on to other panelists if you have questions for them. Keep an eye out this year for updates to the translated country profiles, updated thematic briefings, as Patrícia said, and an update of the other 15 countries that will be coming this year, as well as hopefully some new countries added to the index as well. Thank you all once again to all of our panelists for taking the time and sharing your insights and expertise expertise, for all your hard work on the index and your tireless commitment to addressing the issues that we've been talking about today. With that, I just want to say thank you to all the listeners and participants who joined us today, and enjoy the rest of your day. Goodbye.